Yeah, yeah. First time since 2024 that they've lowered the rate.
Oh, wow.
Yeah. Okay. Let's see here. All right. So the she'elah here is Misha goram nezek lechavero. What we were talking about yesterday, we were talking about how a customer who comes into a store and breaks things has a liability. Sometimes he's liable because he already acquired it, and other times, even if he didn't acquire it, but he's considered to be a mazik on someone else's property, and therefore is held liable. Okay, so the next she'ilah is Misha garam nezek lechavero ve'ein based in yecholim lachufa l'shalim kegon shepater midine adam v'chayiv b'dine shemayim. Person causes damage, but he does so in such a way that it's considered indirect, and as such, the Beis Din cannot compel him to pay. But there are many instances where he's pater midine adam v'chayiv b'dine shemayim, that he doesn't have to pay by human standards, but heaven will hold him liable. Like remember, we learned the case of a person who puts poison or hazardous substances in an animal's feeding trough, and he knows that his friend's animal is going to try to eat that food. That's he's pater midine adam v'chayiv midine shemayim, because he didn't force the animal to eat. The animal came over to eat. Hayim kasher oso adam la'edus o pasal la'edus. So the question is, how kosher is that person? Is he still considered to be part of the group? Is he kosher le'edus? Can he be a kosher witness and so forth? So that's the question that he's asking here, and the response is tshuva misha chayv b'dinei shemayim pasul le'edus ad sheyishalim es hanezek shegaram lechavero. He says, yeah, he's not kosher le'edus even though he can get away with the crime, because the bar is very high on being defined as a mazik. It has to be direct damage. So therefore, if it's indirect, and therefore he was able to wiggle out of a court judgment, he still will not be considered to be a kosher witness until he pays for the damage that he caused. The yeshel of Toras Gezela ad sheyashiv hischova lechavero, because he's considered to be a thief. He's stolen from his friend by damaging something and getting away with it. He says that this is the Sefer HaHashlama, which I'm not familiar with. It's on a commentary on the Gemara. And the Meiri writes this. Okay, he doesn't really give us that many sources for this. I don't, I guess the reason is because Hashem is unhappy with this person. Next, She'ela Misha Niftar Beveistin Betainis Kayamli Kideya Plonis Beposkim Keneged Das Rov HaPoskim. Ha'im Oso Nitva Niftar Gamidine Shemaim Ubedine Shemaim Yeshalav Chiyav La'ashiv Eschova. So the next question is, we talked about this principle of Kimli. Do you remember what Kimli means? Kimli, yeah, Kimli is a phrase that means that a person can sometimes say, I choose to paskin like so and so. And it's a minority opinion, but it's a minority opinion that helps him evade having to pay what the majority of poskim would say that he's liable to pay. Is that person considered to be liable in the law of heaven, that just was able to wiggle out of a claim? See, here in many instances, it pays to be a Talmud Chacham, because then you can know how to respond to the Beis Din. That's why sometimes people will hire what's called a toyin. You've heard of the term toyin before? A toyin is basically a Beis Din lawyer or an advocate who is well learned. And sometimes these guys will find, well, there's one opinion in this sefer that, even though according to the Rambam and the Rush and Tosfos, that my client is chayiv, but according to this obscure source, he's going to be pater. And we paskin like that obscure source, and therefore my client should not have to pay. So the Beis Din may absolve him, or at least absolve him in part because of that argument. So, so is he
Are they
is
obligated then? Do they have to go
the
to that
Basin?
area?
Yeah, the Basin will sometimes have to take that into consideration because as long as it's a legitimate opinion, even if it's a minority opinion, sometimes the Basin will take it. Now, there are times when the Basin will say, well, we're sorry, but case history demonstrates that all Batei Din from the 15th century and onwards have always gone, have not reckoned with that opinion.
Yeah.
The Basin would be within its rights. But sometimes they'll use it to help a guy at least get away with partial exemption. So is that person considered to be off the hook, even midine shamayim, or does a litigant who knows that he's relying on a very flimsy defense, is he liable midine shamayim? So he answers yesh mi shemistapek im chayv latzeis lidechi of yidei shamayim. It's not clear. It's not clear. And who's he quoting here? Knesses Hagdola. Apparently, he lists a whole bunch of rules of when a person can say kimli and when he cannot say kimli. Shaharei la toveya hareze kesafek uveshishneim tonim safek potter af lotzes yad shamayim. He says, when there's a difference of opinion in halacha, then neither the plaintiff or the defendant are definitively demanding that they're either chayiv or potter. Whenever there's a machlokas, he says, and therefore it's not clear whether you have to be yotzei your heavenly obligation by paying the guy back. Okay.
Does it matter with Kimley? Does it matter if it's stature of the minority opinion, though? Like if it's like huge the Chacham's fee or something?
It could be that it will depend on the stature of the person. Okay. Din hamash se kalbo shel chavero b'chavero. Okay, next. The law of what if you sick your friend's dog on another friend? And she'ela mi sheshisa kalbo shel chavero ba'acher v'hakelev nashcho v'gorem nezek livigadav. And the dog bites and causes damage to his clothing. Ha'im hamash sechayv l'shalim es hanezek shenigram l'nashuch. Does sicking a dog, is that constituted as direct damage or indirect damage? Does the person who instigated the dog have to pay damages? Or maybe you could argue he just wanted to intimidate the guy. He didn't know for sure that the dog was going to harm him or his property. And therefore, that's not a person who's liable. He can be held liable in Beis Din. Maybe he'll be chayv b'dinei shamayim, but you can't hold him liable in court. So which one is it?
Or what particular law now?
So actually, there's legislation called the Dog Owners Responsibility Act. It's not intentional. I mean, intentional for sure would be that, but even negligence, you're responsible for your dog.
For your dog. Here, I'm using my friend's dog.
First, well, you could also get it's assault and battery. It's
As if you did it yourself?
yeah.
So something about
You spit on somebody, you throw something.
What if it's not my dog?
Not your dog.
It's not my dog, but I'm able to instigate. I open up the fence so that the dog can run out and harm someone else.
Or if you open up the bee thing, bees go out.
Yeah.
Beating people. Yeah, it's probably an assault and battery also. Certainly intentional infliction of harm. Probably liable.
Yeah. So in halacha, remember anything that's causative cannot be held liable in Beis Din. So misha shisa kalbo shel chavero ba'acher, o shisa bo es hanachash poter mitashlumin, she'eno ela grama b'nezikin v'chayiv midinei shamayim. So if you sick a dog on someone else, or let's say you open up the snake cage and you unleash a snake on someone else, you're going to be putter from actual payment because it's a causative damage. Abal hakelev chayev u'mishalim chatzi nezek. The owner of the dog is going to be liable because it's his property that's causing damage. So, because it's his property, anytime your property causes damage, you're liable, but you only have to pay half damages. Why half damages? That's the Mishnah in Bava Kama. The Mishnah in Bava Kama says that when an animal gores, and it's not known to be a gorer, you only have to pay half damage. That's called a tam. That's right. Bimnoshach hakelev.
It doesn't matter, there's something about first bite or something like that, like the dog, I don't know, but that's
Yeah,
similar
it used to
the
be
three
an old
times.
common law thing called
Yeah.
C-enter,
Yeah.
scienter, where I think this is when they got it from the Gemara, is where every dog was entitled to one bite,
Yeah.
because you're like free, it's like mullet. Then it became a known hazard and you had greater responsibility to look after it.
Yeah.
Yeah, but then they
But that
replaced
doesn't
it in
exist anymore.
Ontario with that Dog Owners Responsibility Act, now it doesn't matter anymore.
And that's just on.
You're just negligent and you know, and it happens and.
How do you spell scienter?
Scienter. It had to.
I've heard it, not that
An
vague.
old doctrine, and that's, it might be sourced in the Talmud.
Scienter doctrine.
Yeah.
Scienter, Latin for knowingly, is a legal term meaning intent or knowledge of wrongdoing, a culpable mental state showing a person knew their act was wrong or acted with reckless disregard for the truth. It's a crucial element in proving fraud, securities violations, and certain torts like strict liability for dangerous animals, requiring the plaintiff to show the defendant acted deliberately, not just negligently. Proving scienter often involves a demonstrating intent to deceive, manipulate, or a conscious disregard for facts, which is a high bar in many cases. Yeah, known as the one but free bite rule. It applies to animal owners who know their pet has a propensity for dangerous behavior, like biting, and are then liable when that propensity causes harm.
This comes from the Gemara.
35 years ago, I had a dog case and they used CN.
Oh,
No.
heard that word.
Yeah,
What happened, what ended up happening?
settled. I never went to trial. But you know, last week, there was a woman who got sentenced to a year in prison for a dog viciously hurting an 11-year-old boy down at the harbor front. But her dog was like this Rottweiler or Pit Bull or something like that, also had a history.
Oh.
And she deliberately walked around without a leash. She was a Meshuggah, you know, and anyway, really hurt the kid. The judge says, enough's enough, you're going to prison. Yeah,
Did they put the dog down?
yeah.
Yeah. Good. Yeah. Okay. Okay, so right. So v'im nashach hakelev es hamashse atzmo poter bal hakelev. If, however, the sicker, the guy who sicked the animal and instigated the animal, ends up getting bitten by the dog himself, so then the owner of the dog is going to be poter. Meaning that if there's any kind of excitation of the animal by the individual, here it's a Gemara in Bava Kama which says as follows: Shisa boas hakelev, shisa boas hanachash poter. So if you sick a dog or a snake on someone else, you're going to be a poter from damages. B'sholim b'Gemara man poter. Who is the exempt party? So Mishiva HaGemara poter mashseh. The person who instigated the animal is going to be poter. V'chayev bal hakelev, but the owner of the dog is still liable. Umasha poter hamashseh kasvu Rabbeinu Yerucham v'Harasham she'af al pi she'osa ma'isa beguf hadavar eno bar hezeka. The reason is because even though you're handling the source of damage, but you're not the owner of that damage. Kishema lo yinashcheu, because you have no guarantee that the dog or the snake is going to bite. V'hanezek lo b'miyad, she'acher hashisui heim noshchim. And also, it's not immediate damage. You sick the animal, but it takes the animal a few seconds to attack. So it's not immediate and it's not definite. The Kosfu HaRishonim, and the Rishonim comment on this, and they say, "Ve'enu domim mashseh shepater lemoser mamon Yisrael la'anas." He says it's not analogous to another case where the Chachamim hold you liable. Let's say you notify someone that who is a person who can take advantage of others in the community, that so and so has money stashed away, and you squeal on your friend, and so that therefore the sheriff of Nottingham comes and confiscates his money. The Gemara there says that even though you didn't physically take the money from your friend's house, you just notified the sheriff where his money is, you're still liable because you've caused a more direct form of damage. So why is that different from sicking an animal? So the answer is V'atam Kosav HaRamban B'dinei Degarmi Huva B'Sefer Pischei Choshen Kevin Shaha'akum Lo Yodea Mehamamon V'Zeh Yisrael Her'ehu Lo Nimsa Shehu Goram Kol Hanezek. He says because by notifying the sheriff that this guy has money stashed away, the entire loss of money was caused through my squealing. Masha'en kein b'mashze koi gavro v'hanachash v'harei zedoma l'momon hamuta l'fnei hamesikin uba acher uba echad v'amar lahem tlu mamon zeh depater. He says in a case where you sick an animal, there's the man, and then there's the animal. So there's a certain I guess the animal is, I don't know, it doesn't sound like a real distinction to me. I guess maybe it's because back in those days, as soon as you told someone that so and so has money, you were giving away their money more directly. He says it's like money that is in front of masikin. But like a person, let's say, owes money, and he tells a creditor to come and take this money. Even though the only reason they're taking the money is because of that guy's advice, I'm not sure if that I understand the distinction. But let's go on. Maybe we'll get further clarity from quoting another opinion, the Mordechai.
Rabbi,
Yeah.
what's the difference between, having the dog damage somebody or if you start a fire?
Yeah, so the Torah says that you're liable in the case of fire. Fire is a case of an inanimate force of energy that you've started and released, whereas an animal is a volitional creature. It's not that it automatically bites. The animal has some level of choice, I guess, and that's the reason why there's a distinction. So let's take a look at the Mordechai. He says, "Kevin shemashse matzi lameimar hol v'yesh ba'olim lekelev hayilem lishmar oser shelo yishtaseh." Another argument, he says, is that this dog has an owner, and the owner should have been controlling his dog to prevent it from getting provoked. Hilchos is chayev bal hakelev v'hamash sapater. And therefore, the owner of the dog is liable because it's his property that damaged, and he wasn't there to guard his property, even though the dog was locked up behind a fence, and I opened up the fence. Nonetheless, if the owner had been there, the owner could have prevented it, which is a really unusual kind of argument. Below dami l'sarv shlarosov shel chaver shchayv, and it's not like if a person incinerates his friends, like here's a discussion of fire, Shmuel. It's not like if I burn my friends' contracts that I'm liable, shegorem shahalova potter velo yifra, because this is, you could argue, isn't that causative damage? Because all I did was burn a promissory note, which basically means that the debtor will be off the hook from paying. He's not really off the hook. It's just that now the creditor doesn't have the opportunity to collect his debt because he doesn't have the paper. Or if I show the sheriff of where this guy's money is, the hasam bori hazeka, shestam ovdei kochavim anasim v'gazlanim. There's a more certain form of damage. See, in all of those cases that we mentioned, that I do causative damage, but it's undoubtedly going to be cause damage. There, like if when I show I tell the sheriff, this guy's got money in the leg of his armchair, okay, and you just have to open it up and you'll see the money, or he's got diamonds in there. So then that's a clear and present damage, because there's no doubt that the sheriff is going to go and invade that guy's house and confiscate whatever he has. But over here, there's still a level of doubt. There's still an uncertainty that the animal is going to cause damage. And furthermore, the sheriff has no one to control him. Whereas an owner of an animal, if he were present, he'd be able to stop the animal. So he says, "L'chora teretz zeh lo mispika gabe machse nechshav elim kain." I'm sorry, it's a printing error. Gabe machse nachash elohim kain hanachash shayach leba'olim, unless the snake is owned by someone, right? In other words, it's not always going to be the case. I was just watching a clip about alligators in Florida. That there's a whole agency down in Florida that's in charge of exterminating alligators that are a public nuisance. Well, what if I find an alligator and I bring it over to your property? Yeah, the whole thing was a cooking show clip. Because apparently there's a restaurant down in Florida that their main protein is alligator meat. And so they were saying that in Florida, you're not allowed to kill an alligator unless it's a known public nuisance, in which case, since they're going to be killing the alligator anyway, you're allowed to use it for food.
That's interesting. There's lots of public nuisance here and you can't do anything about it. Coyotes and
Isn't that interesting?
raccoons.
Well, I would imagine that once the government takes action to eliminate that animal, then there shouldn't be any reason to prohibit its meat. I mean, it's gross. No one would want to eat a raccoon, but no one would want to eat an alligator either. And apparently that's what's happening now.
Well, they say dogs have eaten in certain parts of the world, and so coyotes are not much different.
Yeah.
Well, they banned that though.
Hmm?
They banned eating dogs.
Did they?
Like in the Philippines and a few other.
Oh, really?
Remember years ago, Toronto Sun did a whole expose on it. It became a worldwide.
Okay.
It still goes on in mainland China.
In China, yeah, China. That's what they said. COVID. Remember they said that.
Yeah.
Maybe that was from markets.
Oh, yeah.
So it's interesting. Tosfos says that you're called a mashseh, you're called a sicker, if even you take your friend's hand and you stick it in an animal's mouth. There too, you're not going to hold you financially liable if the animal bites the guy's hand. Why? Because nothing compelled the animal, you're not compelling the animal to bite. Upasa karambam, and it's not clear, it's not clear and present that the animal will bite. Upasa karambam behilchos nizkei mamon ledin zeh uvetur v'imnashach hakelev v'samash zeh atzmo pater bal hakelev. And so then we said at the end that if the instigator himself, the sicker himself, gets bitten by the dog, the owner of the dog is going to be potter. The chol hamishana she'asa davar she'eno ragil ubo acher v'shina bo ve'iziko potter. Because if you take something that's my property and you do something with it that is abnormal, and then you end up getting harmed by it, you're going to be potter. So, for example, let's say I take a piece of your property, I go onto your yard, and I take a rake, and I start jousting my friend with the rake, and I end up injuring myself because I'm playing around with your rake. The owner of the rake is not going to be held liable because you did something that people normally don't do with rakes, right? Which is to start jousting with it. V'hachanami zeh sheshisa es hakelev mishanahu v'chadiisa b'gemara sham. So I don't know if I ever told you this. I'm sure I've mentioned it when I was a kid. We had a dog, and there were kids next door that were throwing rocks at the dog, and the dog jumped up. There was a big fence, a big wall between our properties. Dog jumped up and bit one of the kids who was leaning over, bit him in the face. Kid needed surgery, plastic surgery, and so forth. But and the dog laws in California are just as stringent as they are in Ontario. So you can't use the argument of
Did they sue you?
yeah, of Cienter. We had insurance. I think it was homeowners insurance, where there was some kind of compromise. Cienter
Does it make a difference?
or Cienter, I think it's
Does
pronounced.
it make a difference if the dog is just happens to act on its own as opposed to you giving the dog instructions on what to do?
Well, that's the thing, is that even if you give the dog instructions, the dog is not completely controllable, right? A dog will sometimes, there are times when even a vicious dog will look at a person, and for whatever reason, that person has a very calm demeanor and the dog won't do anything. And then there are other times when the dog will just attack because it smells the fear.
There may even be, I'll look in this legislation, there may be a defense for a dog where you actually bait the dog or, get it all
You
excited.
provoke, yeah.
Provoke it, yeah, maybe a defense.
So let's see, I'm just looking at, let me see if there's a thing called the history of Cienter. Or Cienter.
Or is that used in the legal community? That word, I've never heard that word before.
Yeah, it's an old word. Most lawyers wouldn't know it, but if you're like into personal injury and tort law and stuff like that, you probably would. There also used to be, just sort of a history in Ontario, there used to be, because there's farming, a lot of farming up north and stuff, there used to be an Ox Owner's Responsibility Act too, which had strict liability for an ox that gored somebody. It's kind of like the Gemara, right? It's like Muad, yeah. If you had an ox and it gored somebody, your statute was you're responsible. But they've gotten rid of that because of the common law involved, right? The negligence and.
Dog bites and the doctrine of Cienter. There's let's see.
All these law firms.
Yeah. This is Taylor and Blair from experienced Vancouver lawyers.
What? You should know that.
After my time.
Taylor and Blair.
You guys probably weren't born.
Okay. The doctrine of Cienter, as it relates to animal attacks, basically stands for the proposition that if an owner is aware of an animal's propensity to act in a certain way, that they will then be liable if that previously known propensity to act results in injury to another person. Okay, in these cases, an injured party does not need to prove that there was negligence on behalf of an owner. The doctrine of Cienter will apply and they will be strict. liability, and the owner will be liable for all damages flowing from the attack, regardless of whether or not the owner did anything wrong. So now, experienced dog bite lawyers.
Search up the honest own.
Just looking for the history of Scienter. There is a website on the origins of Scienter, but you have to log in order to access it.
There's so much on it.
Okay, we'll hold it here for today. Okay, have a good week. What about tomorrow? What do you got? What time is
Tomorrow's probably like 8 o'clock out in company, right? It's like a stat.
it's a stat day. Okay, so maybe we'll just regroup on Friday. How's that?
Friday's the same thing.
Oh, Friday's the same thing?
It's
Same.
Boxing Day.
Monday.
Monday.
Okay, we'll regroup on Monday. How's that?
Yeah.
Okay. Take care, everybody.